It gives me great pleasure to welcome you here to this truly unique democratic conversation in partnership with the University of Canberra. I'd like to begin by acknowledging the traditional owners of the land on which we're meeting and pay my respects to their elders past and present. This building, and indeed this chamber, has borne witness to many key decisions over its 61-year history. Built in 1927 and last used as a parliament in 1988, it saw the announcement of a planned intake of 15,000 Jewish refugees from Europe, in 1938. Only 7,000 of them made it to Australia before the outbreak of the war. It was here in this chamber in 1945 that Arthur Calwell, Minister for Immigration in the Chifley government, announced a bold and unprecedented large-scale immigration program that led to over 2 million new Australians over the following 20 years. And it was here too, in 1951, that the Menzies government ratified the United Nations Convention on the Status of Refugees, and 5 years later began dismantling the White Australia policy. Race as a criteria in immigration policy was removed in 1973, and in 1975, the Discrimination Act was enacted, which made discrimination unlawful under the Whitlam government. But it wasn't until 1977 that a comprehensive policy on refugees was adopted under Prime Minister Malcolm Fraser. More than 700,000 refugees have been admitted into Australia since 1938, and more than 6 million have come here as migrants since 1945. So why, might you ask, am I telling you all of this? Well, when you came into King's Hall, you will have seen an unusual shelter standing there. It's a collaboration between IKEA Foundation, Better Shelter, and the UNHCR to improve the living conditions of refugees and displaced people with a waterproof temporary shelter. The idea being to give people who've been forced to leave their homes a safe and dignified place to live. And we're privileged to have one here, the only one, should I say, in Australia, at Old Parliament House. And from Friday, it will be at Floriade as part of our children's offering on the United Nations Convention on the Rights of the Child. And this particular exhibit is focusing on the right to shelter. And it's a particularly timely exhibition, I think, in the context of what's happening in Europe at the moment. Collaboration is a hallmark of what we here at the Museum of Australian Democracy believe in, so I'd like to acknowledge an outstanding partnership that we established in 2013 with the University of Canberra and its world-class Institute for Governance and Policy Analysis. We at the Museum and at the Institute have a shared concern for the state of Australia's democracy, and in particular how Australians perceive and participate in that political process. And so together we set out to understand some of the changing nature of political engagement. And there are some pretty alarming research findings that have come out. Our citizens are overwhelmingly observers rather than participants in formal politics. And 9 out of 10 regard themselves as having no influence over the federal level of government. I have no doubt that these recurring themes of power and powerlessness, voicelessness and being heard are going to be highly relevant for tonight's conversation. So I'd now like to welcome Professor Stephen Parker, AO, Vice-Chancellor of the University of Canberra, who has a long-standing academic and professional interest in these issues. Thank you.
It's my pleasure, ladies and gentlemen, to introduce our speaker tonight and to also express support for the collaboration between the Museum of Australian Democracy and UC's Institute for Governance and Policy Analysis. I'd like to thank Darryl Karp and my colleague Mark Evans for all their work in developing this important relationship. And so to our speaker. Professor Gillian Triggs graduated in law from the University of Melbourne in 1968 and obtained her PhD in 1982. She's the author of many books and papers on international law, including International Law, Contemporary Principles and Practices. Professor Triggs was Dean of the Faculty of Law and Challis Professor of International Law at the University of Sydney from 2007 to 2012. And Director of the British Institute of International and Comparative Law from 2005 to 2007. She's a former barrister with 7 Wentworth Chambers and a Governor of the College of Law. She's been a consultant on international law to a major law firm, a board member of the Public Interest Law Clearinghouse, Pilch, I remember Pilch, the Australian representative on the Council of Jurists for the Asia-Pacific Forum for National Human Rights Institutions, chair of the board of the Australian International Health Institute, a member of the Attorney General's International Legal Services Advisory Committee, ILSAC, and chair of the Council of Australian Law Deans, a position which I once held also, and we both came through it. We did. Professor Triggs was appointed the President of the Australian Human Rights Commission in 2012. Her focus at the Commission is on the implementation in Australian law of the human rights treaties to which Australia is a party, and on working with nations in the Asia-Pacific region on practical approaches to human rights. Most recently, Professor Triggs led the 2014 National Inquiry into Children in Immigration Detention. And although our paths have rarely crossed directly, we've had parallel interests in our academic careers, and it is a great privilege to introduce her this evening, to deliver a lecture on and participate in democratic conversation. Please welcome Professor Gillian Triggs.
Thank you very much, Stephen, and it's a very, very great pleasure for me to be part of this joint exercise, and I must say I'm so impressed by this extraordinary living facility for people who need a home. In the current environment, it really is wonderful to see what a collaboration like this can achieve, and I understand you're taking it to Floriade, and the wider Australian public will see it, so I'm very encouraged by that, particularly given the events of the last few days. In this wonderful, evocative chamber, I am, of course, pleased to acknowledge the traditional owners of the land, the Ngunnawal people, and to recognise their and respect their elders, past and present. Well, I'm here this evening to talk about power and the powerless, and I've entitled it A Year of Living Dangerously. I know that this series was called The Uncensored Conversation, and my staff at the Human Rights Commission thought I was in enough trouble already, and therefore they struck the word uncensored and I think left it at a general conversation. But it is uncensored, I can assure you. But it has been a year of living dangerously for democracy, in my view, and it's rather poignant that in this great chamber I should be delivering such a poor message as I will be tonight. But I think that this has been a dangerous time over the last 15 years or so for democracy, for law and governance, because we've witnessed an unprecedented extension of executive discretion over our traditional liberties and freedoms. Senator Cory Bernard calls this a power creep. I don't often quote this senator, but on this occasion, he's right. For the Australian Human Rights Commission, it's also been a year of living dangerously. We've drawn attention to the erosion of our human rights and to the diminution of the checks and balances that preserve our democracy. All in a year in which, ironically, we also celebrate the 800th anniversary of the Magna Carta. The Magna Carta was at its heart an attempt by the feudal barons to constrain the power of bad King John and to ensure that the sovereign is always subject to the rule of law, and in particular to the common law and to an independent judicial scrutiny. Well, this evening I'd like to discuss the overreach of executive discretion in the dozens of new federal, state and territory laws introduced by recent governments and passed by compliant and complicit parliaments, with the effect of excluding the powers of our judiciary and threatening core democratic principles of the separation of power and the independence of our courts. Particularly troubling has been the phenomenon of the major political parties agreeing with each other to pass laws that threaten our fundamental rights and freedoms that we've inherited from our common law tradition. Indeed, respective governments have been remarkably successful in persuading parliaments to pass laws that are contrary, even explicitly contrary, to common law rights and to the international human rights regime to which Australia is a party. Compounding the concentration of power in the hands of the executive is the recent phenomenon of the increasing militarisation of government and the criminalisation of behaviour that has not hitherto been subject to criminal penalties. A particularly egregious example of paramilitary involvement in civilian affairs occurred just last week when the recently merged Department of Immigration and Border Protection announced Operation Fortitude, under which a coalition of the willing, including the Victoria Police, Yarra Trams, Metro Trains, the Sheriff's Office, the Taxi Services Commission, and the Australian Border Protection Force, agreed to target crimes ranging from antisocial behaviour to outstanding warrants of arrest. The now notorious media release states that the intention was to position the Australian Border Protection officers at various locations around the Melbourne CBD, speaking with individuals we cross paths with. The focus of this strategy was revealed by the warning that if you commit visa fraud, you should know it's only a matter of time before you're caught. It's true that many people are in Australia who do not have a valid visa or who have overstayed their visa. It's also true that a nation has the sovereign right to arrest and deport those who are in Australia illegally. Indeed, the Australian Federal Police, the Australian Border Force officials, and other law enforcement agencies will do so regularly, if quietly, under Section 188 of the Migration Act, that requires, at a minimum, probable cause before a stop and questioning is permitted. But never before have we had Australian Border Force officers planning to stop people in shopping malls demanding identification. Quite apart from the legal fact that these officials do not have the power to do what they're doing or were planned to do, it's a reasonable assumption that those chosen for questioning will be those that fit a racial profile contrary to the Racial Discrimination Act. Melburnians reacted to the media release by demonstrating within a couple of hours on the steps of Flinders Street Station, blocking traffic, I'm told, to the irritation, of course, of the commuters. But within hours, Operation Fortitude had been cancelled, and all concerned have since run for cover, blaming low-level officials. It's notable that the Australian Border Force Bill itself slipped through Federal Parliament's House of Representatives in March this year without a single opposition party member speaking against it. Only Scott Ludlam and Sarah Hanson-Young questioned the bill in the Senate. Gone are the former values of the Department of Immigration in favour of a command and control strategy of the new Department of Immigration and Border Protection. Well, Operation Fortitude raises many questions and illustrates to a high degree the kinds of concerns that I have. But my particular question tonight is, how is it that public officials within this new super department and the Australian Federal Police and the Victoria Police and all the other agencies involved, whether senior or not, did not ask whether such a paramilitary operation was consistent with Australian liberties? Are we as a nation, and are our government officials so ill-informed about human rights under the Constitution, under the common law and under international law, that no one within government thought to question so obvious a violation of our right of freedom of movement, to walk the streets without fear of being stopped or questioned by officials? Operation Fortitude is but one example of the tendency to increase executive power and to criminalise behaviour. Australian governments have introduced and parliaments have passed scores of laws over the last 15 years that infringe the rights to freedom of speech, of association and movement, the right to fair trial, and the prohibition on arbitrary detention. These new laws undermine our robust democracy, especially where they grant discretionary powers to executive governments and ministers in the absence of meaningful judicial scrutiny. As President Woodrow Wilson remarked, liberty has never come from the government. Liberty has always come from the subjects of government. The history of liberty is the history of the limitation of government, not the increase of it. So what explains Australia's move to restrictive approaches to our fundamental freedoms and human rights over the last few years? I suggest that there's been a conflation in the public mind of the events of 2001, nearly 15 years ago. And to remind you, there was the Tampa crisis on the 26th of August that year, the children overboard misstatements of the 6th of October, later, of course, to be found to be completely unsubstantiated, and a month after that, on 9/11, the terrorist attacks on the United States. Since these events, governments and political leaders have played on community fears of terrorism and the unauthorised entry of refugees to concentrate power in the hands of the executive to the detriment of our liberty. While I will focus tonight on the proposed bill to strip citizenship from Australians with dual nationality and the extensive use of administrative detention, some recent examples illustrate the risks to democracy. And just a very few, and I will go through a few of them. Under our counter-terrorism laws, Australians may now not enter declared areas, declared of course by the government, such as the Mosul district of Iraq and Al Raqqa province of Syria. A criminal prosecutions attracting a 10-year penalty in prison, and which place the evidential burden on the accused to show a legitimate reason for being there, will now attract severe penalties. Any disclosure of information in respect of special intelligence operations will attract mandatory 5- and 10-year penalties, but the ASIO officers and other security officers engaged in special intelligence operations have total immunity from civil and criminal prosecution while engaged in these operations, even outside the mandate. And we've also seen restrictions on freedom of association in laws such as the Baiki laws. But in considering these examples of legislation, the test of the validity of law, both at international law and the views of the Australian High Court, the jurisprudence developed by that court, is whether it's necessary and proportionate to meet a legitimate aim. Individual laws may very well pass that test, and perhaps it could be argued that we should wait and see how these individual laws work in practice. Should we wait for the prosecutor to prosecute my son, who happens to be a bikie and has some fairly undesirable friends? Do we wait until he's prosecuted and see what actually happens before we start to argue that these laws are invalid? Do we wait to see whether anybody's actually prosecuted under the declared areas law in relation to Iraq and Syria? In other words, why would you waste your breath complaining about these laws until you wait and see how they're actually applied in practice? But my concern, particularly over the last 3 years as president, but if you look back over the last 14 years, is that as each new piece of legislation is passed, they accumulate and become more than the sum of their parts, demonstrating a systemic and disproportionate intrusion on our individual liberties. And this gradual accretion means that we appear to be sleepwalking into an increasing autocratic state. But of wider concerns than perhaps the pieces of legislation that I've suggested are broader principles, and I've referred already to the independence of the judiciary and the doctrine of the separation of powers. And I'd like to give one example of that, and there are many across Australia, but one is the diminution of judicial independence in the Northern Territory's paperless arrest laws that were introduced last year under the Police Administration Act. Under these new laws, a person may be arrested without warrant and detained for 4 hours or significantly longer if intoxicated, if the police officer believes on reasonable grounds that the person has committed or is about to commit an infringement notice offence. Now, those offences, when you look more closely, is failing to keep your yard clean, singing an obscene song, or playing a musical instrument so as to annoy. I think many do that in public transport all the time and annoy me deeply. There is no obligation to bring the person before a judge for offences that do not, in some cases, even attract themselves the sanction of imprisonment. The detainee can be held on mere suspicion until the police decide to release them without charge, issue a fine, release them on bail, or bring them before a court. Sadly, such detention disproportionately impacts our Aboriginal and Torres Strait Islanders, contrary to the Race Discrimination Act. Over the first 3 months of this year, the arrest and detention powers were used to arrest 500 people in the Northern Territory, 70% of them Aboriginal. Tragically, an Aboriginal in the Northern Territory, Mr. Langdon, died aged 59 this year in May after being held for 3 hours under these laws. And it's worth remembering that this event has arisen 24 years after the Royal Commission report into deaths in custody in 1991 that recommended that arrests should never be used unless they are a last resort, and only by refusing to use imprisonment of this kind was it possible to stop the Aboriginal deaths in custody. The coroner in the Northern Territory, I think, courageously recommended that the arrest laws be repealed for their discriminatory impact. Well, underpinning my concerns about executive overreach is the doctrine of separation of powers. that's vital to our democratic system. It's a concept that lawyers learn about in law school, but which is hardly ever part of public commentary and infrequently taught to our younger school students. In brief, we've got three arms of government: executive power vesting in the Queen, exercised by the Governor-General and by government, Parliament with the power to pass legislation, and the courts with the power to interpret the laws and determine whether the laws have been complied with. And that three-part check and balance through the process is not often discussed. We tend to think that once a government's been elected, then the government has the power, providing it can get the numbers in Parliament. And one of the tragedies has been that Parliament is often compliant with passing these laws. Well, the rationale for the separation of the three arms of government is that sovereigns or executive governments, from King John of Magna Carta to Charles I of England, who of course lost his head, to the present day, will almost always seek to augment their autonomy. This is a given, but it's the function of Parliament and the judges to provide the checks and balances against the inevitability of executive overreach. And it's been the institutional failure of Parliament, in my view, over the last decade that poses one of the greatest risks to our individual liberties. There is a challenge now to the police powers in the High Court, the Northern Territory laws, and the argument is that the arrest and detention powers are inconsistent with the judicial power of the court to impose punitive or penal sanctions. In short, their submission is that the Northern Territory cannot exercise executive powers of penalty. Only the Northern Territory courts can do so. And here is the argument that the Solicitor General put just a few days ago to the High Court of Australia. That is, that the doctrine of separation of powers has no application in the territories. To maximise, and this is the Secretary General, that's the Solicitor General of the Northern Territory to the court, he says, to maximise flexibility, the Parliament must be free to make whatever arrangements it wishes in respect of territory judiciaries, including legislating for and maintaining control and administration of the judiciary, and completely transferring control and administration of the judiciary to the territory politic under its own legislation. A quite extraordinary answer, and he's also argued that arrest and detention powers are not punitive. Well, the Australian Human Rights Commission has been granted the power by the High Court to make submissions, and we have put our case that firstly, the arrest and detention powers are punitive and penal, and therefore for the courts and not for the executive, but also that there is a diminution in the independence of the judiciary. We know that the jurisprudence developed under international law, and particularly the International Covenant on Civil and Political Rights, that protects the right to liberty, can inform the power of the judiciary in determining their powers and determining the jurisprudence. But it remains to be seen what the court will decide, and we hope that we'll get a decision fairly soon. But another element that I wanted to raise was the growth in the phenomenon of mandatory sentencing, which again also excludes the judiciary from making their judgments. It's been very unusual to find mandatory sentencing laws at the federal level. It's been rare, but recently there's been an expansion of those mandatory laws in the context of people smuggling. But these laws are much more common in the state and territory laws, particularly in Western Australia, where the Sentencing Act creates very particular sentences that judges are bound to impose, and whether those offences are brought is a question for the prosecutor, giving again the executive very high levels of power and leaving it to the judge simply to rubber stamp ultimately the sentence that is to be applied. Another significant threat to our liberty, I think, lies in restrictions on freedom of speech. And perhaps we could go back a little bit in history, because you'll remember that this government came to power arguing that it was necessary to amend the Racial Discrimination Act, Section 18C, on the grounds that it offended the freedom of speech. So we had a government in its opposition period, and when it came to power, arguing that freedom of speech was risked or at risk by the Race Discrimination Act. And just to remind you, Section 18C provides that it's an offence to offend, insult, humiliate, or intimidate a person in public because of their race. And you'll recall that Mr. Bolt was prosecuted under this provision, much to the fury of members of the government. And that seemed to drive this need to protect the right to freedom of speech. Now, reasonable minds, in my view, might say that the words offend, insult, humiliate, and intimidate need to be reformed. They don't quite get to what we're really interested in, which is racial vilification, hatred. There was a case for some amendment, arguably. But that argument was really not made in a coherent way. And you'll recall that the Australian public, a little bit like the Operation Fortitude, the Australian public responded very, very quickly indeed. In a multicultural society, the religious groups, multicultural groups came together and they said that it was necessary to protect this right to prosecute for intimidating and humiliating in the public arena, where it was done because of race. And we saw that the government retreated from that position and decided not to go forward with the exposure draft for amendment. Now, that was an instance in which the government had promoted the idea of freedom of speech. But since that time, we've seen a 180-degree turn, enacting new laws that disproportionately reduce the right to freedom of speech. And one of many examples is the Australian Border Force Act, passed earlier this year, that subjects medical officers, teachers and other professionals employed by the Department of Immigration and Border Protection to a 2-year prison sentence if they speak out about the conditions in immigration detention. Now, it may be that that will be applied in a moderate way by a prosecutor, but on the books, on the legislation, this is a damning piece of legislation that prevents professionals speaking out about the conditions in these detention centres. And if I can add a more personal note with regard to the inquiry that, as President, I called in relation to the prolonged and mandatory detention of children in detention. One of the most important parts of that inquiry was that to each detention centre and to Christmas Island on each occasion, I took with me a child psychiatrist and a paediatrician and other medical officers who were able to speak with authority and credibility on the condition of these children, whereas obviously I and my colleagues at the Commission did not have those skills. So it became crucial to the power and credibility of that final report that we were able to have medical officers speaking out. And the intention of this legislation, of course, is to prevent that and to create a chilling effect on those professionals. I should say that it hasn't actually affected those who've been willing to speak out. They've decided to take the government on. But we've also got new crimes of advocating terrorism. We have new provisions for data retention laws applying to the entire Australian community that seem to be extreme. Curiously, while the government must apply for a warrant in relation to journalists' information, and to compel the surrender of a journalist's metadata to identify their sources, that warrant is not available in respect to any of the rest of us. So although the media was able, perhaps like the squeaky wheel, to argue that they needed special protection, the rest of us can have our metadata accessed without a warrant at all. And yet, oddly, the content of our emails cannot be accessed without a warrant. But as I've learned, you can actually learn a great deal more about a person from the metadata by triangulating all that data that's available through metadata than you can from the content of an email. But these are things that perhaps are complex. The Australian public doesn't fully understand what this really means, and they go through Parliament with very little debate. We also have problems in relation to good governance principles of transparency and process. Senior appointments or captains' picks made by Cabinet without the usual, long-established public processes of advertisement and competitive selection. We have secrecy and lack of transparency with regard to so-called on-water operational matters, and we have very significant non-compellable ministerial discretions of ministers, particularly under the Migration Act. Well, these broad concerns raise for me a very obvious point, that it's Parliament that passes the laws. What are the proper limits on the power of Parliament? What are the safeguards of democratic liberties if Parliament itself is compliant and complicit in expanding executive power to the detriment of the judiciary and ultimately all Australians? What are the options for democracy when both major parties agree on laws that violate those fundamental principles of the common law and Australia's obligations under international treaties. Well, I think this rather parlous state of affairs has arisen because Australia is exceptionalist or isolationist with respect to the protection of human rights. You'll be aware that our Constitution protects very few freedoms. We have the right to freedom of religion, basically designed to prevent a religion being established, the right to compensation for the acquisition of property, and the right to vote, and the High Court implies a right of political communication. But there's very little else. The Constitution was drafted as a practical solution to the need to establish a federal structure that respects the rights of the states, but it was not inspirational in the way that, for example, the United States Constitution was intended to be. As is also well known, unlike every other common law country in the world and most civil law countries in the world, Australia has no charter or Bill of Rights. This means that we do not have the core benchmarks against which to measure or challenge the laws that breach fundamental freedoms. It's notable, for example, that the United States Supreme Court could appeal to the 14th Amendment on equality before the law to decide that marriage is available to all, including those of the same sex. We have no such capacity for our courts because we have no benchmarks against which they could consider matters of this kind. Despite what I've said, however, about the lack of domestic constitutional or legislative protections, it remains true that for the most part, Australia has been a good international citizen. We've played a strong role in negotiating human rights treaties, and we've been instrumental in achieving the monitoring regime that has been fairly successful over particularly the last 20 years or so. You'll remember that great Doc Evatt, that rather irascible but brilliant lawyer, managed to get the Universal Declaration of Human Rights through the General Assembly when he was president, when Australia was president. He got it through the General Assembly without a single negative vote. And from those times on, Australia has been a strong player in the international environment, very significantly drafting and negotiating the International Covenant on Civil and Political Rights, Economic and Social Rights, and the non-discrimination laws in race, women, and disability, and of course, most recently, being the International Criminal Court through the Rome Statute. But the great problem has been that Australia has not in the main implemented those treaties in domestic law. And you'll all understand that diplomats can't go off and negotiate treaties and have them apply to Australia until Parliament decides to pass them into domestic law. And that hasn't happened with regard to the main treaties, such as the International Covenant on the Rights of the Child, on the Convention on Civil and Political Rights, nor has the Convention on the Rights of the Child, which is the subject of the exhibition here at the Museum of Democracy. That also is not a directly available part of Australian law, astonishing though that seems. And indeed, we now have the extraordinary phenomenon that where we have implemented some of those laws in our domestic laws, we're now stripping them out of those laws, so that the Refugee Convention provisions have now been stripped away from the Migration Act in recent laws passed over the last few months. So that the question of what is a refugee is now a question for a departmental officer and ultimately for the minister, but not for international law, despite the fact, of course, that Australia is bound by it. The compounding phenomenon is that we live in an unusual part of the world. Latin America, North America, the whole of Europe, Africa, and most recently the Arab states all have charters of rights and commissions and courts to develop the jurisprudence and to develop a reasonable regional understanding of what human rights means. But in our part of the world, it's not easy to talk about the rule of law with any real meaning. It's difficult, it's growing, it's improving, but we're still a long way from anything like the European understanding of the concept. And we have, of course, no regional charter of human rights, and we've no commission or court to develop jurisprudence. But then it might be said, well, we can rely on our courts to protect common law principles. We can go to our High Court and we can argue that the legislation breaches common law principles or our international treaty obligations. But the difficulty here is that while the courts have developed the common law principle of legality and the presumption that Parliament intends to comply with international law, that only applies if the legislation is unambiguous. If the language is clear, the courts must apply the language on that clear on its clear terms. It does not have a right to simply go back to common law principles. So that when we look, by way of example, at the Malaysian case, we find that the High Court could strike down the Malaysia solution on the basis of Section 98A of the Migration Act, which required that a nation had to have ratified the Refugee Convention before we sent a number of asylum seekers to Malaysia in their swap deal that was proposed. And the High Court struck that down, and it did so because of the provision in the Migration Act. Well, you all know what happened next. The government went straight back to Parliament, and they eliminated Section 98A, so that there was no possibility of going back to the High Court on any other example of that form of offshore migration swap. So, time and again, the High Court has tried to limit executive discretion, but time and again, government has been successful in asking Parliament to tighten up. Well, I wanted to say, before I finish, just a few words about the counter-terrorism and loss of citizenship laws, which is, again, a recent example of the problem. We do need to reform our counter-terrorism laws. They're out of date. They're based on the idea that it's states that commit offences and that you support states. That's not the case anymore. We're dealing sometimes with lone rangers or with completely maverick groups that may have terrorist objectives. It's much more difficult to deal with, and we need new laws. But I'd suggest that the strength of the rule of law is more truly tested when security is threatened than in times of peace. When Australia is threatened by terrorism, the need to protect our traditional liberties assumes an even greater urgency. Many counter-terrorism laws, again introduced with unseemly haste this time last Christmas, go well beyond what might be deemed to be proportionate, creating a chilling effect on our various liberties. And the Australian Citizenship Allegiance to Australia Bill has now been introduced, I think being debated this week, to ensure that Australian citizens accused of fighting for or in the service of a declared terrorist organisation or acting inconsistently with allegiance to Australia, a phrase or a concept for criminalisation that we've never had in Australia before, they will be stripped of their citizenship automatically, including that of their children if they're dual nationals. The wording of the bill is indefined, but does include damaging Commonwealth property as one of the bases on which we would be considered to have acted inconsistently with our allegiance to Australia. I'm not sure which of us knows what is Commonwealth property and what is state or territory property, but it gives you an idea of the extreme breadth of this kind of legislation. The loss of citizenship for dual nationals, I believe, strikes at the heart of Australia's successful migrant and multicultural nation and threatens social cohesion. Under current law, the power of the minister to revoke citizenship arises if a conviction for the specified offences has been made. But that need for a prior conviction has now gone. The conviction will apply automatically, presumably noticed by some medium level or middle level official who will then report it to the minister, and the automaticity will take place. It's a curiously phrased piece of legislation because the revocation occurs automatically with a subjective power of the minister to extend a waiver to anybody that he chooses on the grounds that it's appropriate. If the minister considers it appropriate to do, then the person will be excused. The minister cannot be compelled to exercise his discretion, and if he makes any mistakes, he is not bound by the rules of natural justice. Well, Magna Carta, of course, has something to say about it. No man may be outlawed or exiled except by the law of the land. And that does raise the question of whether it's consistent with the rule of law for Parliament to pass laws that withdraw citizenship automatically. I suggest that to do so is contrary both to the spirit and the rule of law under the International Covenant on Civil and Political Rights. The government argues that the right to a fair trial and the role of the courts is not threatened by the bill because there's a judicial review of any decision made by the minister to exempt a person from the automatic loss of citizenship. That's true. A court can review whether the power under the Citizenship Act has been exercised according to law. But all the law requires is that the minister exercise the discretion as he considers appropriate. In short, then, the courts have nothing to review in practice, and the exercise will be futile. In this way, the courts are excluded from the process other than the theoretical power to review the unreviewable. Well, the last example I wanted to mention is that of arbitrary and indefinite detention and the enduring words of the Magna Carta. No free man is to be imprisoned except by the lawful judgment of his equals or by the law of the land. And in recent years, parliaments have passed many laws that detain indefinitely various classes of persons. You'll all be, I think, well aware of those laws in relation to mandatory detention of refugees, but there are also those who have infectious diseases, who are mentally ill or unfit to plead to criminal charges, who are subject to mandatory admission to drug and alcohol rehabilitation facilities, or people who are deemed to be dangerous by the minister, or subject to a classification as a dangerous sex offender. Few of those detained under these laws have meaningful access to legal advice or regular independent judicial review. The Human Rights Commission is particularly concerned by the growing instances of detention in prison of those with cognitive disabilities. In a recent complaint that I made findings on and recommendations in respect of, arose in the context of 4 Aboriginal men with cognitive and intellectual disabilities who have been held for many years in a maximum security prison in the Northern Territory. Each of the complainants, the men who'd been held, had they stood trial, they would have been subject to a maximum sentence of a year, of 12 months. But because they argued that they were unfit to stand trial, or the authorities did for them, they were imprisoned for 4.5 years to 10 years, respectively. I found as president that this was a violation of the right not to be detained arbitrarily under Article 9 of the International Covenant on Civil and Political Rights, and of course inconsistent with the spirit of the Magna Carta. The detention powers of the executive have also expanded, of course, to detain asylum seekers and refugees. And we know that the High Court of Australia in Al-Kateb in 2007 agreed with the legislation, the Migration Act power, which allows and mandates, indeed, the detention indefinitely. That was a 4-3 decision of the High Court that has yet to be overturned. Most egregiously, those with ASIO adverse assessments, not subject to judicial review, are detained for many, many years, including children who are held today in Villawood. At the moment, exactly 2,026 people are being held in closed, mandatory and indefinite detention in Australian detention centres, including 118 children. 943, typically young males, remain on Manus Island, and 448 refugees are on Nauru, including 89 children. Most have been held for about 1.5 years, several of them for many years longer than that, and the conditions have been described and criticised by the United Nations rapporteur under the Torture Convention for breaching that convention. It is an extraordinary phenomenon that if you think back to the days of Doc Evatt and the Universal Declaration, we should now be attracting the criticism of the United Nations on the grounds that we are in breach of the Torture Convention. And the response, as you know, from the Australian government was, we do not want to be lectured to by the United Nations. Well, there are some rays of light. One of them is a recent and very little discussed decision of the High Court of Australia, which unanimously, doesn't happen all that often, but unanimously confirmed a writ of mandamus against the Minister for Immigration to require him to make a decision to either grant a visa or to deport, one or the other, within a reasonable period of time. Now, this was a decision about 3 or 4 months ago in the S4 case, and I think it could be, although it's had little media attention, I think it could be a turning point, because it means that the High Court, through this ancient writ of mandamus, will be keeping an eye on what the minister does, and that people cannot be held for years without either being allowed to apply for a visa and being assessed as a refugee, or being deported. And one of the very sad facts is that up until just the last few weeks, 33,000 people remain in Australia where their claim to refugee status has not been assessed. And one of the saddest things that I've observed in my time going to the detention centres has been that while they expect poor conditions, they expect to be detained for a period, they had no reason to believe that they will be denied the right to make their claim as a refugee. And they say that that's the refusal to accept their status as a refugee and to dismiss them as economic migrants or opportunistic migrants is the last stripping away of their dignity. And the assessments have only just started, and I think sadly we will expect a much higher rate of decline than the current, or the rate that was in existence before the current policy and currently exists in Nauru and Manus, where something like 85 to 90% are found to meet the legal definition of refugee. Well, in conclusion, one of the many lessons that I've learned over my 3 years as President of the Commission is that one of the most effective safeguards of human rights is the cultural expectation of Australians that our freedoms will be protected. While most Australians are quite unlikely to be able to describe the doctrine of the separation of powers, they're quick to assert their liberties under the rubric of a fair go. It's a phrase that I think is as close to a Bill of Rights in this country as that we're likely to get. This cultural expectation is what keeps our freedoms alive today, as was illustrated in the overwhelming community response to Operation Fortitude and to Preserve 18C of the Race Discrimination Act. The scores of laws recently passed that infringe our rights has confirmed my view that Australia needs at least a legislated Charter of Rights at the national level. If the law fails or is imperfect, it can be amended or repealed, and that's relatively easy to do. A national priority, I think, is to educate or promote the education of young Australians so that they better understand and value the constitutional protections for democracy and understand what is meant by that oft-used but little understood concept of the rule of law. So, finally, while it has been a year of living dangerously, and I have challenged the power of the executive, I hope that as an English migrant and as a dual citizen, I keep my passport, I escape statelessness, and I eventually retire to smell the roses. Thank you all very much.
Thank you very much, Gillian. We now have a few minutes, about 10 minutes for questions, and so I was wondering if I might ask you to come back to the podium and to see if anyone has any questions that they would like to ask.
Hello, Madam President, and thank you for that. I work for Amnesty International. I had the pleasure of writing our submission to the Universal Periodic Review, and I was just wondering whether you could comment on your expectations of how the government will respond to that review in November.
Look, that's an important question because I think not a lot of Australians understand that we're going through this process. And perhaps I can preface it by saying that you may know that Australia is seeking a seat on the Human Rights Council, which is the peak and a major body within the United Nations system. That body is a reformed body from the old Human Rights Commission, which was much criticised. But this new body, the Human Rights Council, has been significantly more successful and respected. And what it's done is adopted a policy of 4 yearly universal periodic reviews. And Australia has been through the process once, and we're now about to go through the next process in November, coincidentally with what will be the formal announcement by the Foreign Minister of our intention to seek a seat on the Council itself. As it happens, I brought our Universal Periodic Review report because we have the standing in the UN system to report independently to the Council, and I've brought that report with me, and some copies are outside if anybody wants to have a look at it. The aim of the review is to see I think Australia was asked to make something like 190 recommendations, deal with a number of recommendations from other countries about breaches of human rights, typically dealing with Indigenous Australians and asylum seeker policy. And Australia agreed to most of those recommendations at the time. But the challenge 4 years later is to see the extent to which we've actually complied with those recommendations and undertaken to achieve, or have we in fact achieved, what we promised to achieve 4 years ago. Sadly, only 11% of the recommendations that we accepted have actually been carried out and have been met by Australia. Now, what Australia will say in response, it remains to be seen. In other words, Amnesty International's put in your report, we've put in ours, various others will. The diplomatic service here in Canberra has been extremely interested in those reports. They're going back to their governments in order to be sure that informed questions are asked of Australia in November. I think Australia will argue that some have been addressed, others have partially been addressed. And I think it's what's meant by partially that's going to be the difficult issue. And one of the things that we want to propose is that the recommendations are more precise, because at the moment they're so broad that it's very easy for a government to say, well, we've partly complied with it. So it's a process. But I think this time my guess will be that there will be a considerably robust level of questioning of Australia at this November meeting. So I think it would be important to keep an eye on just what that is like, what the process is like.
Hi, my name is Elizabeth. You talk about Australia's cultural expectation of a fair go. As citizens, how can we best defend and uphold that in our daily lives and in our responses to things past, Twitter?
Well, of course, the social media has become so powerful. I mean, that was really what got those people at Flinders Street Station. I think that to do the sort of work we do at the Commission, we have staff who monitor every piece of legislation that's going through. We look at every amendment, we look at the consequences of each one in human rights terms, we give evidence to various committees, and we're on the record. But that's not going to affect the public. And so now increasingly I'm saying to people, speak up individually. Use whatever resources you've got to speak up when you're concerned about something. But be alert, be alarmed and alert at what is happening. Because I think only if we don't have the leadership at the political level, and if Parliament will not stand up for these principles, then I think the Australian public, individually or in their networks and groups, have got to start speaking up. Because in the end, we can do only so much, or Amnesty International can only do so much. But I think if you're making sure that the facts are right, making sure that you've seen what the law is, and then making your judgments and speaking up, I think I'd like to see that happening more. More op-eds, more pieces in social media that are informed pieces, not abusive, that's something that adds to a rational discussion. But I think the more people that speak up, the more difficult it is for Parliament to simply allow these laws to be passed. We have to challenge why citizenship should be lost without a conviction by a judge. It's not that we're saying we don't have the sovereign right to take away citizenship. Of course you do. And if people fight against Australian interests, we've got a sovereign right to judge that citizenship should be lost as a consequence. But the process is throughout the world, and up to now, under Australian law, is that a judge makes a conviction, determines the facts, looks at the evidence and the law and makes a conviction. Then you have the process of losing citizenship. But to do it automatically with an element of subjective, effectively non-reviewable discretion by the minister is deeply wrong. And I think Australians need to speak up about it. And of course, one point that needs to be made, I made perhaps just a joke at the end about dual citizenship and me, but how many Australians have dual citizenship? Very, very millions of us. I think somebody estimated 4 to 5 million of us either have dual citizenship or are eligible to apply for dual citizenship. Now that's a very, very destabilising thing to do, and I think we should be speaking up about it. Not to say that we can't strip citizenship, of course we can, but to say it must be done according to the rule of law. That's really my point. So I come back again and again, each of us must speak up.
Professor Triggs, thank you for the work that you do. You've partially answered this. I agree with you that we are in a state of living dangerously. You talked about social media and personal responsibility of people. Are there any other solutions that you would suggest so that we don't have to live so dangerously in the future?
Well, of course, I understand this question because I think people listen to these concerns. And they've varied, over the last year or so, whatever's been in the news I've tended to speak about. But I think we have to write to our backbenchers. Backbenchers count, as we know. Write to them. And it doesn't have to be a long letter, but a paragraph to say that you're deeply concerned about this. and that there are fundamental freedoms or fundamental processes that should be gone through. So that's one. I think write a letter to the editor, write op-eds, use your social media, or if you're a member of Rotary or a university or you're a club, speak up about it. One of the things that I think has been quite extraordinary is young people are well educated and they have a social conscience, but they don't like political engagement very much. My own children don't want to be engaged at a political level. They want to get on with their lives, they act hopefully in ethical ways, but they're not actually very interested in politics. And I think that we're losing those young people because they're so disillusioned by a political process where we don't have viable leadership with vision, with ideas. We have political debate at a very low level, as we've seen this afternoon. I think we've turned young people off, and I would like to see our educators reinvigorate our young people to get engaged. Just before I came here, I did a session with Jewish students of Australia who are doing something at the new Parliament House, and they're students who are trying to build an engagement in the political environment, but that's relatively unusual. I was formerly Dean of the Sydney Law School, and I was astonished at how non-political they were. It made my life a lot easier, I might add, Stephen, that they weren't for my generation in the 60s, my goodness, we wouldn't have let a dean off the hook for a minute. Things have changed dramatically, and I'd love to... I'm not calling for people to be out in the streets, I'm not calling for aggression or abuse, I'm calling for reasoned, evidence-based argument to call attention to Australians about the core values of a fair go. I know it's an overused phrase, but Australians get that. They get fairness. And I think we should appeal to it because it's something that came out of our literature and poetry in the 40s and the 50s. It's part of what we are, and yet it's slipping away from us. And we're not really aware of how dangerous this is. What goes around comes around. What we saw... What we allowed our border patrol officials to do in Nauru and turned our back on it and turned a blind eye to it, comes down to us in the shopping malls of Melbourne when they're suddenly patrolling the streets asking where their visas are. Maybe that will, when it did, of course, get people out. And maybe that's when we start to see it reverberating on us, that we've not cared about the rights of others, but suddenly we find that those infringements of liberties come back to haunt us, then maybe we'll be more active. But I think it's imperative that we are.
On behalf of all of us, I would like to thank you for that wonderful presentation speech and those extraordinarily provocative ideas, because I do think these are dangerous times, and I think they are times that we need to take very seriously, and certainly here at the Museum of Australian Democracy, we are continuing to engage in the sorts of conversations that I think need to be had as to what makes informed, engaged conversation and active citizenship. And so on behalf of all of us, I would really like to thank you very much for being part of it today.